Yeah, the ACCC's 2018 Enforcement and Compliance Priorities is a document they put out every February, which sets out the way they're going to be spending their money in terms of enforcement in the coming year. So it's a guide to businesses to the areas that the ACCC think are important, and they'll be spending a lot of time looking at very carefully. Well, there are two reasons the ACCC has enforcement priorities. First is governance. Like, obviously it's good to be transparent with business about where you'll be spending your resources and what you think is important. But the other reason is purely practical. They receive so many complaints and they need to be able to have some way of culling those down. For example, last year they received over 400,000 calls from different consumers. Of those, over 200,000 were put into their databases, raising potential contraventions. So they need priorities to be able to identify what's important and focus their resources in the most cost-effective manner. Currently, the penalties for breaching Australian consumer law are $1.1 million for a corporation per contravention, or $220,000 for an individual for each contravention. But that will be increasing by the middle of the year. The government has put forward some legislation to increase the penalties so that they're much more significant. These changes, which will come in on the 1st of July, will mean that the maximum penalty for a breach of Australian consumer law will be either $10 million per contravention, 3 times the benefit which the company gains from the contravention, or alternatively 10% of their turnover. So the way that works is, if the benefit that the company makes from misleading its consumers can be calculated, then the penalty will be set at 3 times that value. So if there's a marketing campaign based on a false representation which nets a company a profit margin of $5 million, then conceivably the penalty will be $15 million. Alternatively, if it's impossible to work out what that benefit is from the misleading representation, then the company could actually be fined 10% of its turnover, which you can imagine, if there's a company with hundreds of millions of dollars worth of annual turnover, the fines could become multi-million dollar fines. Well, there's 6 industries on the ACCC's 2018 hit list. The first one are the broadband providers, to look at the various speeds they're telling the consumers they can achieve. The second one is car retailing, so they're very conscious of the consumer guarantees that car retailers are offering their customers. The third one is the energy sector, which has been an area where the ACCC has been looking at them for many years now. There's also the franchise. Large national franchises are going to be a focus in 2018. Digital platforms, so companies like Google, Facebook, they're being looked at very closely in 2018, and the ACCC is actually conducting an inquiry into that sector. And finally, financial services, which has been in the news a lot lately with the Royal Commission, and the ACCC's really ramped up its activities in that area. There are 5 different areas which are considered enduring priorities. In other words, areas that the ACCC will always have it on its hit list because they're so important. The first is criminal cartels. The ACCC has a dedicated team to look into criminal cartels, and it'll spend a lot of effort trying to uncover those. The other area is anti-competitive agreements, so it'll be looking particularly in 2018 at the new Section 46, misuse of market power provision, which has changed, and also coordinated practices, which is a new law in the Act. The other 3 areas, the first is product safety, most notably the Takata airbag recall, which is being ramped up as a mandatory recall. The ACCC's got a big job to do there. And the other final 2 areas are vulnerable and disadvantaged consumers, so people who may be elderly or with disabilities who are being ripped off. And finally, Indigenous consumers. So they're very keen to look at Indigenous communities, remote communities, where Indigenous people are being sold products that they don't require. Well, 2 good examples of Australian consumer law breaches are firstly the Nurofen case, where Nurofen was selling different pain relief products at different prices, and claiming that some of the products were specially formulated for certain types of pain, for example, back pain. But in actual fact, all the products were identical. So consumers were paying more for what they believed was a special product when they were getting nothing in addition to the standard product. So that was a case ACCC litigated and ultimately got a fine of $6 million out of the manufacturers of Nurofen. Another more recent case relates to Heinz, who were selling certain products for children as nutritious and healthy, and they'd made numerous representations of the packaging to convey that idea to parents. And it turned out after the litigation that the products weren't nutritious or healthy at all, rather they had up to 60% of sugar in them. So they're two cases that the ACCC took in the last couple of years, just enforcing the Australian consumer law. Well, the first thing a company has to do is, if it doesn't have a competition and consumer compliance policy, it needs to bring one in. So that means that they've got to look at introducing a policy which sets out your obligations as a company to obey the law, both the Competition and Consumer Act and the Australian Consumer Law, appoint a compliance officer, also conduct a risk assessment, really work out where you have risks under the legislation. Then also complaints handling is very, very important, a way to capture all the complaints that you receive and analyse them and respond quickly to consumers. Also annual training, telling people about the law. The staff need to know what their obligations are. And finally, just telling management what is going on in terms of compliance. Really, the compliance has to start at the top of the organisation. And for those companies which have a compliance program in place, it's always good to get a review done of them, because sometimes they're not being understood very well, or they're not keeping up with the times. So even if you have an existing compliance program, it's a pretty good idea to review it every couple of years to make sure it's still current.